Hello and very warm welcome once again to the Tax Express. In this important video, we shall be discussing an important judgment in the context of levy of penalty and interest on wrongful utilization of ITC. The Honorable Madras High Court in the case of Green Star Fertilizers Limited has recently delivered this important judgment on the issue whether penalty under section 73 or 74 can be levied when ITC has been wrongly availed but not utilized. In this case, the petitioner reversed an ITC of rupees 11,27,932 before issuance of show cause notice under section 74. However, the AO imposed penalty on this reversal amount under section 74 at the rate of 15% as emphasized in section 74 itself. It may be noted that section 74 provides for imposition of penalty at 15% if ITC has been reversed before issuance of show cause notice. Aggrieved by the said demand, the petitioner filed a writ petition before the Honorable Madras High Court and contended that Section 74 makes it clear that there must be a revenue loss to the government. But in the case of the petitioner, the ITC was never utilized in setting off any outward tax liability, meaning thereby that there was no revenue loss as there was no reduction in outward tax liability as a result of such availment. The court heard the rival contentions on both sides and held that penalty under Section 74 is not sustainable. The court referred to the judgment of Honorable Patna High Court in Commercial Steel Engineering Corporation versus State of Bihar. In this case, the Honorable Patna High Court has held that if the credit reflected in e-credit ledger was availed or utilized for meeting any tax liability, then the action taken by the department in imposition of penalty would be justified. But mere reflection of ITC in e-credit ledger does not result in reduction of tax liability. The provisions of Section 73 are self-eloquent, and it is only if such availment is for reducing a tax liability that it vests jurisdiction in the assessing authority to recover such tax together with levy of interest and penalty under Section 50. But until such time that the statutory authority is able to demonstrate that any tax was recoverable from the petitioner, the reflection in the e-credit ledger cannot be treated as an availment. Relying upon this judgment, the Honorable Court held that no penalty can be imposed under Section 74 on mere wrong availment but not utilization. However, the court imposed a token penalty of Rs 10,000 for wrong availment of ITC on the petitioner. As we have seen, this is a significant judgment from the point of view of justification of penalty imposed under Section 74 for wrong availment of ITC which has not been utilized. We know that under Section 50, interest on wrong availment of ITC is levied only on availment and utilization of ITC in accordance with Rule 88B. In line with this provision, imposition of penalty under Section 74 even on reversal before issuance of show cause notice appears to be harsh and unjustified, particularly in cases where there is no utilization or set off against payment of any outward tax liability. So this is a welcome judgment which underlines that penalty is not justified where there is no reduction in tax liability, where credit is only reflected in e-credit ledger, there is no revenue loss to the government, and therefore imposition of penalty is not justified. Stay tuned to the channel and subscribe if not done so far for more such updates on GST. Thank you very much.